SJC-12655, Commerce Insurance Company v. Justina M. Szafarowicz.
Am I off that last game? Okay. Okay, so I'm not on this, I wasn't a single justice on it. Okay. Sorry. Okay.
Mr. Graceffa, just to get our bearings, we're talking now about the settlement, correct?
This 655 is the deposit into court.
So this is the post-judgment interest issue.
Correct.
Okay, just want to make sure we know which of the two we're dealing with. Okay.
Thank you, Chief Justice Gantz. Good morning, members of the court. It's a pleasure to be here. This is the first of two issues that this court has taken up sua sponte from the appeals court, which both arise out of an incident in August of 2013. Perhaps the best place to start is with the most recent event in this case. We filed a motion to supplement the record appendix, attaching for this court's consideration, if you accept the motion, Judge Wren's decision on the insurance case, which we tried last summer. Judge Wren, after hearing seeing 40-odd exhibits and hearing witnesses, determined that there was no accident which occurred here, and that indeed there was only compulsory coverage and no optional 5 coverage. The event that brings us here today on issue number 1 occurred in February of 2017. We, at that point, filed a motion to deposit the entire remaining limit of the commerce policy into court. Before we get to February, we need to go back 3 years. The declaratory judgment action was filed in January of 2014. The wrongful death action had already been filed. Both actions moved concurrently. A lot of events occurred in the end of 2016. The wrongful death case was moving to trial, and at that point, we moved to intervene in the underlying case, the wrongful death case. Judge Davis wrote a very thoughtful decision in which he referred to under litigation and so forth, and denied our motion at that point. We then moved to stay that case and have the coverage case tried first. Once again, that motion was denied. The agreements, which are the subject of the second appeal here today, were executed in 2016. We have twin agreements, one with Matthew Padovano, the driver, one with Stephen Padovano, the father and truster of the vehicle. In those agreements, which we will talk about a little bit later, there was essentially a confession of negligence, and nothing was left except for a determination of damages. After those agreements were signed, Commerce once again filed an objection in the wrongful death case and attempted to stop the second half of the wrongful death case, the assessment of damages. We argued that case. Mr. Slotnick argued that motion. The judge denied it.
So the solution to who has to, bear the burden of the appeal as to interest, I guess you would say would be do the declaratory judgment first and see if there's coverage.
That's correct.
And that would presumably solve much of the problem.
That's correct. In a case I argued in this course in which Chief Justice Gantz wrote the decision on behalf of the court, the Metropolitan versus Morrison case, he indicated in a situation different than this, but a similar coverage situation, that an insurance company that has a bona fide coverage question reserves its rights, defends, moves to stay the underlying case, and receives a coverage determination.
right.
We attempted to do that several times, Your Honor, and each time we were turned away, so
it's
to
an
speak, from
abuse,
the court.
it's an abuse of discretion for the judge not to do the declaratory judgment first? Because that gets tough, right? I mean, I understand once the two things separate, we got a real problem. And there's such a huge separation here. That causes the interest to run. But it really is an abuse of discretion not to do the declaratory judgment first? Any cases that say that?
No, Your Honor, and it's a tough standard, I agree with you. But in this particular situation, because of the facts, because of, I think, Commerce's now correct decision, according to Judge Wren, that there was no accident, we believe from the inception, and we're defending the entire time, both insureds, that there was a bona fide coverage dispute. Once we got to February, we had to contend with a $7 million judgment. At that point, we looked at the case law, we looked at Rule 67 of the Rules of Civil Procedure, and went all the way back to Justice Greeney's decision on behalf of the majority in the Davis case. Justice Sossman and Justice Greeney had a debate, not the right word, but they were responding to each other. And Justice Sossman's comments were very thoughtful, and Justice Greeney's decision, I thought, was also very thoughtful. In footnote 13, as we've argued in the brief, he indicated that, although not in that case, there was the possibility of a procedure to stop the running of post-judgment interest.
It wouldn't stop the running of interest. It would stop the running of interest against your client, right? Nothing could stop the running of interest. It would just shift it would somehow put the burden back on the plaintiff, right? I mean, the defendant, the insured, right?
That's correct.
Isn't that the problem, is that the situation then becomes unfair to both sides? You have to pay an extraordinary amount to be able to have your appeal on whether there's coverage, and then the plaintiff, and I understand it's actually the estate here, but the plaintiff has to wait, and the insurer can take as long as the insurer wants to decide whether or not to pay the judgment.
Well, I don't think that's completely in our control, Your Honor.
I
mean,
understand, that's my concern. It seems unfair to both sides.
well, in this particular case, and it's a very good point, there was an agreement. It's a unique case because under the agreement signed by the two Padavanos, they had no responsibility for post-judgment interest. They had no responsibility anymore. So it is a fair point that could be, in certain circumstances, a shifting away from the insurer to an insured, but they were released. They had,
So in this case, assuming with that, what would have happened had the estate been entitled to recovery? Would you be responsible for the post-judgment interest, or would it have been stopped?
no. If this court accepts the suggestion of Davis, and we had been allowed to put the $480,000 plus, to that date, accrued post-judgment interest in court, and then gone ahead for 2 years, and we had lost the case 2 weeks ago, then the interest and the $480,000 as paid in February of 2017 would be the amount paid.
Okay.
So
let me ask-
that, and the unfairness, Your Honor, I'm sorry.
No,
to
go
interrupt.
ahead.
The unfairness would be that because that motion was denied and 2 more years went by, 2 weeks ago we received a decision. Had we lost, the interest running on that $7 million is $912,000 a year. The limit here is $500,000. So we believe in this unique case, where there's a bona fide coverage issue, where we have filed timely a declaratory judgment action 3 times, tried to stop the train, so to speak, of the wrongful death case, and couldn't. and understanding the abuse of discretion standard is a high one. Once we got to the point of February of 2017, we looked for a alternative. And the alternative we found was in Davis.
Now, let me ask you, even before Davis, or without Davis saying what Davis said, could you have suggested this remedy just based on Rule 67?
I don't think so.
And
I
why
don't-
not?
I think if you actually look at Rule 67, my memory is there's nothing in there about interest. It permits the payment of money in the court. Yes, it does. But in the circumstances of Davis, Justice Greene suggested that because of the issue.
And
It was a different case, but in that case, the actual interest was 10 times the policy limit. Yes, Your Honor.
Now, in this instance also, I think your brother says that that there has to have been a bona fide offer, or that there has to have been an offer or something before you could be permitted to put something into escrow. Is that correct? Maybe I have that wrong, but that there has to be some offer.
Under the Davis versus
Under the Davis,
Allstate
right.
case, there had to be an unconditional offer to pay.
Okay, that's it. Now, are you arguing that where there's a bona fide coverage dispute, that's really the equivalent for purposes of the interest and the rule?
With the footnote that the $20,000 mandatory limit had always been on the table, first. And then second, Your Honor, when the judgment came down, we immediately, once again, tendered the $20,000 with all post-judgment interest on that amount, and that's in the record.
Isn't there a tension in the footnote with the rest of the opinion? Because the rest of the opinion says they can't settle without you, basically. The plaintiff, the insured can't make the case go away unless they have your money. So the case isn't going to settle without your money on the table, but your money isn't on the table when it's a qualified offer. So I find it difficult to reconcile that footnote with the rest of the opinion. It looks like it's a response to Justice Sossman, but isn't the whole point that without your money, this case isn't going to settle, so the interest should be put on you? I think that's what Graney was saying, wasn't he, the rest of the opinion?
Yeah, but it's a different situation, Your Honor. In the Davis case, as you will recall, both Allstate and the insured wanted to appeal. They believed they had bona fide rights to appeal. Allstate had made an offer to settle, and there's a distinction drawn in the opinion about that, an offer to settle for the $25,000 early on, but they wanted a release. That was refused.
Right.
Then the appeal happened, time went by, and we got to the situation where the $25,000 was then offered unconditionally, and the plaintiff said, well, you owe us $250,000 in post-judgment interest, and that was the essence of the opinion. What makes this case different, and it is a different case, is by analogy, we have a coverage dispute which is marching down the road, taking time. We moved it as quickly as we could. And it was a situation where we were left with no alternative at that point other than to attempt to pay the money into court.
If the case had been kept together, if they hadn't severed out the declaratory judgment case from this, I know you want declaratory judgment done first, but I think that's a tough road to hoe. But if they'd been kept together, the case, right, we didn't sever them, this wouldn't have been a problem, right? If the judge had said, okay, now we're immediately moving to decide the declaratory judgment issue, then it would have gone away, right?
Right. I mean, it's a practical...
That was the real problem. Once these two ships started sailing in different directions.
Right. As a practical matter,
And can I ask one follow-up question to that? Is this a problem that's gone away because the model insurance provision now imposes the interest
no, Your
only?
Honor, and it's
Okay.
a very good question.
Okay.
The 2015 and 2016 form limited post-judgment interest, as you just said, to within the policy limit. This 2008 form has been used for a long time by a lot of insurers.
So it's still
Oh,
out.
Take a while to get.
There's a multitude of claims out there concerning this form. Also, we have this case to contend with, and If it's other insurers, I believe, are using other forms. So that standard form is not completely controlling. And other lines of insurance have the same problem. So this is an issue out there.
Now, the,
If you had done what you had hoped to do, which is deposit your 480,000 plus change into the court, and now you have prevailed in the DJ action, at least pending appeal, is it your contention that you get your money back?
Get what money back, Your Honor?
480.
We didn't, the court refused
No,
to
I
take
know,
it.
I know, but if you had, if the court had said, sure, put it into an interest-bearing account,
I misunderstood, yes,
your view is that you would get the money back.
yes,
So your view is that payment was conditional on the outcome of the DJ action.
yes.
So let me go back to Davis. In Davis, going to note 13, again, it's hard to know what Justice Graney meant, but was that $25,000, if the defendant had prevailed on appeal, would the view be that the insurer would get back that 25 grand?
In that case,
Your colleague's
No.
nodding his head.
in that circumstance, Your Honor, I believe the answer is no. This case is different.
So that, but I guess the concern is, Justice Graney is, I mean, as I understand it from having read Davis all too quickly last night, you have Justice Graney says it has to be unconditional. You have to give him the 25 grand, and then you're done. And then we have Justice Sussman saying, wait, we just said in Lazarus that you can't make the insurer pay the money unconditionally, because then you may arguably violate your duty to the insured.
Right.
So that's, I think, when he refers to the disturbing ramifications that he's responding to her use of the term to say, this is a problem because now we're telling you the only way in which you can avoid paying interest is to do what in Lazarus we say would arguably breach your duty to the insured. And so he says, well, here's this other way to do it.
Right.
But I'm trying to figure out whether doing it then means it is a conditional payment, which is conditioned on the outcome of the appeal, and in your case, conditioned on the outcome of the DJ action, in terms of whether you get the money back, depending on how it plays out.
Well, clearly, our understanding in our case was that the 480 and interest to that point, if that had been accepted and stopped and we prevailed and the estate did not appeal, we get the money back in our case.
and the appellees say that's the problem, is that, that there's going to be a huge incentive for the insurance company to proceed on a reservation of right.
And I think we responded to that in the reply brief, Your Honor. For us or the industry to reserve rights willy-nilly or without basis is an extremely dangerous proposition. It doesn't
You'd be
happen.
backing into a 176D problem, wouldn't you?
Right. And also, there's an appointment of counsel problem there. If we reserve our rights, it becomes very expensive for the company. The same argument was made in another case I argued here, the Facion versus CNA case, and Justice Sussman, perchance, responded to other counsel, and I made the point that if we did that, that was a PIP situation. We have exposure under 93A and 176D, as Your Honor just mentioned. I just don't think, based on my representation of these companies for all these years, that just doesn't happen as a practical matter. Just reserving your rights, you need to have a reason to reserve your rights, or it's just fallacious. I see my time is up.
It is?
Thank you.
Mr. Bukowski.
Good morning, Chief Justice and Justices. David Bykowski for the state of Justina Szafarowicz. Just piggybacking off of the discussion that we just talked about, the first thing that I think is important but isn't mentioned at all is the obligation to pay interest arises out of a contractual obligation that's set forth in the policy. It's the additional cost section that says, in addition to compulsory, and in essence, I'm paraphrasing now, in addition to compulsory and optional coverage, we will pay interest that accrues after judgment is entered in any suit we defend. We will not pay interest after we have offered to pay up to the limits you selected. The offered to pay language was what was interpreted in Davis as an unconditional payment. What's important in this case is that, A, the post-judgment obligation is not triggered by coverage. It's triggered by defending. And second of all, coverage has never been an issue in this case. It was always known that there was coverage, that there was compulsory coverage. The only question was whether there was optional coverage, which went to the duty to indemnify. It's not a situation where, if the insurer was successful in the deck action, there would be no coverage in the case.
Okay, so let me ask you the same question I asked your brother. Since they have, at least at the trial court level, prevailed on the DJ action.
Right.
If they had put their 480,000 plus change into a court or interest-bearing account, is it your view that they would get their money back, or is it your view that you're still entitled to post-judgment interest because you have the $20,000 of mandatory?
Okay, so A, we're still entitled to post-judgment interest because that's what the policy mandates, and Davis says that we're entitled to it until there's an offer to pay. However, what it would have been is, I mean, in essence, this is an interlocutory appeal of the denial of Commerce's motion to deposit money with the court conditionally pursuant to Rule 67, where the controlling case law, Davis, specifically holds that the money being deposited be paid unconditionally.
And that's what I'm trying to figure out with regard to Justice Graney, note 13, because I understand your point. He says, no, you've got to give it. Offer to pay is different from offer to settle.
Right.
It's unconditional. But then he responds to Justice Sospeson's concern, and he says, okay, I'll give you this alternative. But I don't, the alternative doesn't mean much if you don't get the money back, depending on how the appeal plays out. I'm just trying to figure out what you say should.
Okay, so in other words, first of all, he didn't give them, if you will, he didn't give them an alternative. He had a footnote, which at best was dicta, where he proposed a procedure with no analysis. And the answer to the reason why that procedure doesn't work was immediately addressed by Judge Sossman in her footnote number 7, where she refers to it as an oblique suggestion, which was made without any analysis. Actually, without analysis is my word.
Much tougher back then.
No,
towards
an
the
oblique
judge.
suggestion, and what she says is 3 things. A conditional deposit into court is not an offer to pay under the insurance contract, which is what the majority just held. The insurance policy does not suggest that such a procedure relieves the insurer of the obligation to pay interest on the entire judgment if the appeal or deck action is unsuccessful. Now, if it was a deck action with no coverage, then that's a different kettle of fish. In this case, the insurer always knew there was coverage, and in addition to their deck action, they have appeals on which we're here today that have outlived the deck action and are continuing to boost the post-judgment interest. And by the way, the appeals are not in the interest of the insured, but they're specifically together with the deck action for the benefit of the insurer, and their remedy for this situation would be immediately on their deposit, conditionally to shift the burden for post-judgment interest to the insurer.
So if it were not conditional, the deposit with the court meant that they couldn't get the money back? How are they going to, I think this is a point in, maybe in the reply brief, how's the insurance company ever going to be able to litigate the coverage issue if it's unconditional.
Okay, so in other words, the argument, in essence, for the insurance company is a fairness argument. And in the entire fairness argument, we're not hearing anything about the contract, and I'm going to answer your question, Justice. I'm not hearing anything about the contract, we're not hearing about the consequences to the insured, and of course, we're not hearing about the consequences to the judgment creditor, which is always in the picture on the other end of all of these cases when an insurer and an insured get in a dispute like this. But the answer is, Commerce had a number of options, and whether we think they're great ones, we can go through them. And their options, first of all, was to do the analysis at the time, a case analysis the way they always do in every case where there's appeal, a risk-benefit analysis, which factors in what their costs are going to be and what they're going to be exposed to and whether they should settle and whether they should make an offer. They could have resolved the case according to the terms of the insurance contract and what.
But the problem is, but, I mean, say, if Judge Wren is right,
Yes,
this doesn't work, your approach. Once these two cases separate, that's the real problem. Don't you, in order for this to work sensibly going forward, shouldn't we make clear you can't allow these to separate with this interest problem? Or inevitably, somebody is going to get
okay, so,
damaged here, because I agree with you that you can't let the insured can't settle the case, so the interest is accruing, but they can't contest the coverage case. As soon as those things depart from each other, the whole thing's a mess, isn't it?
well, not really, because after the
I don't see
judge,
how they're protected. I
Okay.
understand, you're protected now, but we want to protect both of you from this
Okay.
in the future, don't we?
I'm going to address that.
Yeah.
The day after the judgment came down, if Commerce was so convinced that their position was correct on the deck action, they could have paid the $20,000 compulsory coverage and 1 day of post-judgment interest, which would have been $2,500. They then could have gone forward with their deck action.
But
If
the,
they,
but the interest would still accrue on the $7 million.
yes, but under the policy, their obligation would be finished, and that's what they're seeking to get
Really?
out of today.
You're saying that they, boy, I'm surprised by that.
Okay,
You're
so-
saying that they could have paid $20,000 plus 1 day of interest, and then under the insurance contract, they would not have an obligation to pay any more interest after that?
Yes, because of their additional costs out, that's what the language says. And by the way, they can throw the policy limits up early and get out altogether in these
But
cases.
they paid you the 20 grand even before the case was settled, didn't they?
No,
Yes.
no, not before the case went to judgment. It was offered, but with a release. So, in other words, and I.
20 grand? I thought they paid the 20 grand right off.
No.
I could be wrong.
No.
I guess I am wrong.
They never paid the 20 grand. So if they offer the 20 grand plus the 1 day of interest, they end their obligation under the policy, okay? If they win the deck action, because they've paid everything they could have paid on liability unconditionally, and everything they paid the post-judgment interest at that time.
So
And they can do that under their contract.
the interest would only accrue against the estate at that point?
Against the insured, yeah, and that's a terrible, that's not a good result either, but that's what we're talking about based on the language of the policy and based on what they do all the time to get out of.
But again, if there's a dispute about whether they have to put in the other $480,000, I'm amazed, given how skilled the lawyering here is, that that's true. There's a dispute over the $480,000. If you offer the mandatory amount, you're off the hook on interest? And how do you do that with that contract, which doesn't make that distinction?
No, if they end up offering it and they win the deck action, if they win the deck action, if they lose the deck action, then it's not unfair for them to have to pay the $500 together with all the post-judgment interest that accrued while they pursue it. It's like having what you believe is a meritorious appeal.
They had offered under this Rule 67, if they'd put in $20,000 plus $1 of 1 day of interest, they're off the hook?
They don't need to use Rule 67. Rule 67 is for unconditional payments. All they would have to do under the policy, which is set forth in Davis, is to cut the check and send the interest. And under their additional costs provision of the policy, they would be off the hook at that point.
If they win the declaratory judgment.
Right, but if they lose the declaratory judgment and the declaratory judgment takes time, why should the insured be responsible for the interest?
It doesn't make sense either way.
Right, and why
Doesn't
should the
make sense
judgment
either way.
creditor not collect the interest, which is one of the things that Davis says, we're concerned about what the interests of the insured and the judgment creditor are.
I hear you loud and clear, just like I heard them loud and clear that they shouldn't have to pay for the declaratory judgment action. It's unfair to both sides.
Well, if we have a situation where there has to be an allocation of interest and insurer is charging premiums based on risk, and when the insurer pursues their own interest, which is to the detriment of the insured under the insurance contract, to transfer the obligation to them, win or lose, for interest to the insured makes no sense at all. There are options for commerce, and the one I said is absolutely the best option, and you don't require a deposit under Rule 67, which stands Rule 67 on its head, which requires an overruling of Davis, which transfers the burden of the interest to the insured, and there's a few other provides commerce with essentially a risk-free deck action in terms of interest. On any appeal, interest we have a concept for post-judgment interest, and there's reason for it. And they specifically assume the obligation in the statute to create a situation where the insurance industry is entitled to a risk-free, not even appeal, but in a risk-free deck action to try to get out from underneath coverage for their insured, while all the while transferring the obligation of the interest to their insured while they do it is unfair. And because there's a contractual provision, what commerce does in this case is they file a deck action seeking to enforce all of the contract obligations against the insured to get out from underneath having to pay under the policy, while at the same time asking the court for relief, from their obligations under the policy. That is not fair. And in addition, in the Rule 67...
The policy says after we have offered to pay up to the limits you selected.
Right, but I think a fair reading of that is going to be ultimately what they're responsible for. If they weren't responsible for anything, they wouldn't... For example, if there's...
So if there were no mandatory here and the entirety of their coverage was at issue, they would need to pay nothing and be protected?
Well, there wouldn't be any interest they'd be responsible for under their contract, right?
There
Because
would be if they lose the deck action.
Huh?
Or they would be, I mean, I'm trying to figure out, so I mean, here you happen to have a insurance coverage where there is some which all agree exists, the $20,000, and then as to the balance, which is $480K, there is a dispute. But in many insurance policies, the entirety of coverage is in dispute.
Right. It depends on the wording of the additional costs, what obligation they assume by contract. We can't just ignore the contract, even though it isn't discussed in the briefs and not argued. They enter into an insurance contract where they make representations and and they have obligations to the insured, and they write the contract. And as you know, that somebody mentioned, it's been rewritten to cut down their obligation on post-judgment interest in the 2016 version. But the contract, the supplementary insurance payments are straightforward, and the cases that come from around the country say it means what it says. And what it says, you have it, but basically, it doesn't even tie in their obligation to coverage. It says in cases we defend, we'll do this. And then they say, whoa, we actually don't want to do that. That's not fair. That just doesn't make sense. But that's the contract that they wrote. And that's what, and the language is still in the same way, Judge.
They didn't write it. Isn't it determined by the
It's the fair
insurance
meaning of the
commissioner?
terms of the contract.
This interpretation that they only have to put in the 20, where do we, can we find support for that besides you out there? Is that going to be in some case, or that you're only responsible for the compulsory as opposed to the additional amounts? Because I'd like to read that, because that just seems like this case would have gone away if that were that clear. Where these guys could pay $22,000 and preserve all their rights.
Oh.
I suspect they would have jumped at that opportunity if that were clear in the law, but.
All right. Subsequent to the denial of this motion, at some point in time, Commerce did exactly that. They sent us unconditionally $20,000 together with what they, by their formula, determined to be the appropriate post-judgment interest.
So they did that.
We'd say that it was not appropriate, so it didn't end their obligation under the policy,
I'm
but we,
confused now, because you just told me that would do it. So wouldn't that, as a contractual matter, stop everything and shift the interest onto your client then?
well, the interest onto the insured, my client is the judgment creditor.
Right, yeah.
If they had paid the $20,000 together with all post-judgment interest due, okay, back in August of 2017, which is when I believe they attempted to do it, at that point in time, interest would have continued to accrue up until the time of the deck action. And at the time of the deck action, when they won the deck action, and it was determined they only owed $20,000, then their argument, I'm sure, would be we paid the 20 together with all interest due in August of 2017, therefore we have no further obligation. We've satisfied our obligation under the contract.
That doesn't help them, I mean, that doesn't help if they lose the declaratory judgment, because they're on the hook for the interest to use their words, access the courts on the coverage issue.
Well, but it's the same thing for an appeal, Judge. It's the same thing for when they appeal on behalf of their insureds, and they're responsible for interest, and it's the same thing for all kinds of litigants who have judgments against them in terms of judging their ability to appeal or what they believe is meritorious. Some people just can't do it, but we're talking about carving out a special exception where we suspend the entire amount of post-judgment interest from running, and that was one, I was trying to get to that before. One of the things that they argued during the hearing when their motion was denied was not only this concept in Davis of ending post-judgment interest accruing for the insurance company, and there's no mention, Chief Justice, of that being conditional at all. It doesn't say that conditionally. They just as easily could have been saying, pay in this money unconditionally, and you're done. But what they said during the
You were just in the midst of saying, they will say that having paid the 20 grand.
yes,
Plus some interest, I guess, only on the 20 grand, that means they're off the hook, and you say?
if they had paid the 20 grand together with the appropriate amount, what they owed for post-judgment interest.
Which would have been about how much at that time? Just
I don't remember
Just
exactly.
ballpark, we're talking about,
$76,000 a month for 8 months. They could have done it, I say, one day afterwards,
So we're
but by that
talking-
time, it's about 8 months afterwards, $560,000.
Okay.
Don't hold me to it.
okay.
I think it was about $76,000 a month. Now, and this argument will come up, and we may be back on this someday. They're going to say that they extinguished their obligation. But what I just wanted to add.
I mean, just to be clear, you're saying that to extinguish their obligation, they would have to pay the 20 grand plus the 560.
Plus their post-judgment interest.
Which would be
up
about
to the time.
$560.
Yes, up to the time they satisfy the additional cost
And
provision of
instead, they
their
pay 20
policy.
grand plus another, what, $1,000 as interest on the 20 grand, or not?
No, it was a different amount. If we get into that,
But
we'll
it's
be
a
here all day.
small amount, I gather.
Less than what they should have. They came up with a formula, which some of it was based on interest and some loss of use of money.
Okay, but it was well below the 780 or whatever that you say they would have had to pay.
Yes,
Okay.
at that time. They could have done this earlier. At the hearing, though, the initial hearing on the motion, they also, a fair reading of the transcript of the hearing, they were not only arguing to cut off their obligation Commerce's responsibility for post-judgment interest, but they were arguing to deposit the money and end the obligation for post-judgment interest running altogether, which is what Justice Kafka alluded to at the beginning. You can't do that. And
Right, but in
that's a problem.
reality, that has no consequence because your agreement means the only people who can pay are going to be them. Pursuant to the settlement that you reached, all the parties are out. They have no more, they're released.
Yeah, that's going to be.
So there is no practical difference. I mean, I understand your argument is that there is theoretically a difference between we don't need to pay the interest versus their interest does not need to be paid. But here, that's purely theoretical.
No,
because you've released all the parties that would otherwise have had to pay that post-judgment interest.
Well, the problem is the judgment creditor is the person who's entitled to the post-judgment interest. So the post-judgment interest for the delay of the payment of the money, the whole concept of post-judgment interest is that the judgment creditor should get that. And Davis recognizes that the insurer is in the best position to do that, and by shifting the obligations of they go through a whole balancing test, which is.
Okay, but you can't go after Father Padovano and Son Padovano for any of that money.
No.
For any of the
No,
of the
and
post-judgment
Davis specifically says the ability of the insured to pay excess or pay post-judgment interest is not relevant to the analysis.
Okay, all right, we're going to take our break and we'll have part 2.